Okay, we're all set to go. Mr. Fredericks, you're going to be first. Do you want to reserve 5 minutes, sir, for rebuttal?
Yes, please.
All right, 5 minutes it is. We're ready whenever you are.
Yes, good morning, Your Honor. May it please the court. My name is DJ Fredericks, and I represent Ms. Jill Busby and Gary Christensen in this case. And we are seeking a reversal of a final judgment awarding expert witness fees to James Essenson, the appellee. The initial final judgment was entered awarding expert witness fees pursuant to Rule 1.390, and it is our position that the judgment should be reversed because Mr. Essenson did not meet the threshold determination established by this court as an expert witness entitled to compensation, and as such, he's not entitled to costs for the filing of the motion for protective order in the trial court, and we would seek a reversal of the order awarding those expert fees and direction to award fees to my clients.
Mr. Fredericks,
history of this case.
Mr. Fredericks, let me just kind of cut to the chase, and if I may. In this case, from reading the briefs, it appears that Mr. Essenson, when he represented Mr. Christensen, there was a bit of, let's just say, the relationship soured between the two, but he nonetheless had provided representation to them. So here are the key facts as I see them, and then I'll get to my question. So he represented Christensen for a portion of the underlying litigation. And then Christensen ultimately, prevailed on that litigation that Essenson had withdrawn. And because he ultimately prevailed, he became the prevailing party for that matter, entitled to fees, and then made a request to Mr. Essenson as to tell me what your fees are. Apparently others in the same case had been signing an affidavit as saying what the amount is. In this case, as I understand the facts, Mr. Essenson did not or chose not to sign an affidavit and instead insisted on getting a deposition. So which leads me to the question. The question before us is whether his testimony, his deposition testimony constituted an expert witness, which the trial court ultimately decided, or whether in the context of this case, he was in essence a fact witness. So that's our determination. Was he a fact witness or was he an expert witness? And it muddies a little bit because he's an attorney, which muddies the water, which then brings me this. In this case, when he provided his deposition, he's the one that testified as to what services he provided to his client, correct?
Yes.
All right. So he testified as to the services that he rendered. This is the amount of money that I billed. This is the amount of that. It seems to me that's a factual witness. What did the judge and their order, the judge seemed to come to the conclusion that by virtue of his testimony, it somehow rendered him to be an expert witness. Help me out with that, because I thought the whole purpose of the deposition, at least he was providing information as to the services he provided. And so help me out. Why did the court came to the conclusion that he would be treated in the status of being an expert witness?
Yes, I think it boiled down to the idea that just because he's a lawyer and because he could be considered an expert, he's automatically entitled to a fee. And that's simply contrary, though, to this court's determinations in cases that are analogous to what we're dealing with here today. Specifically,
in this case, Mr. Fred, as I understand, I'm reading through the record, when there was he even had another lawyer, and his name escapes me right now. It's in here somewhere, to testify as to what the amount would be reasonable. And in essence, he had his own expert witness to testify what the amount of his fees ought to be. Am I correct?
Judge, you're right on point. Exactly. The purpose of the testimony is at issue. There is no question that Mr. Essenson is likely considered an expert in his field. That's not, he's practiced for many years. I'm not contesting that. But this case is analogous to what happens with doctors. And I've cited multiple cases that establish there's a threshold determination necessary to determine whether or not a doctor, who is generally an expert in their fields, is entitled to an expert fee as well if they're a testifying treating doctor for the patient. And that's what we have here today. Mr. Essenson was the representing attorney You hit a nail on the head. He testified as to the discussions about no charges, duplicative entries. Why did he do work? What work was done? That's all fact testimony, and that's what was provided. In fact, the transcript has zero mention of the word opinion in it. That is because...
Doesn't he take a position on the reasonableness of his own fees?
No, you cannot testify as to the reasonableness of your own fees.
I understand he can't, but didn't he?
No, and Judge, respectfully, I would suggest he did not. And the reason why he did not is because he was the head of the firm. What did your firm do? Why did you do this work? This case was heavily contested from the beginning. We're talking from 2013 to 2019 when the original final judgment was entered. Every facet of this case was heavily litigated, and including this part. And frankly, if that affidavit that was executed by 3 other firms was executed, we wouldn't be here today, which simply outlined exactly what the questions that I asked him at the deposition. What did you do? How much did you bill? What was your hourly rate? All those facts that are necessary to submit to the court to determine the lodestar figure and the competent substantial evidence to establish the amount to be awarded. And
so you never asked him if what he had done had been reasonably necessary for the case?
The question was what the work that he had done wasn't reasonably necessary, the work that he had done, not whether or not his hourly rate was reasonable, or whether or not the hours that he spent were reasonable. That is for a separate expert to testify, which was mentioned by previously in the question. A separate expert is required to testify as to the reasonableness of the hourly rate and the number of hours spent. Mr. Essenson cannot, in case law that I've cited in the briefs, testify as to the reasonableness of his own fees. That is a clear, the case law is clear on that point. Competent substantial evidence, which required his deposition testimony, and then a separate expert to testify whether or not that competent substantial evidence establishes the fees are reasonable. And that's what happened here. And that's analogous to the case law that I've cited, specifically Santa Lucia versus Diaz and Field Club Alario, which are both second DCA cases that talk about treating physicians. And in fact, in Field Club versus Alario, there is a particular point that states that treating physicians is generally not classified as an expert witness. Nevertheless, when they give an expert opinion separate from their fact testimony as to what they did for the patient, that's when that threshold is met to get to the point of being awarded an expert witness fee. And in fact, as well as Santa Lucia versus Diaz, 2 of the 3 treating doctors were not awarded expert fees. That's because they did not give expert opinions as to how the work that they've done and the impact that it would have in the future, the opinions to provide to the court. Here, that's the same thing. Mr. Essenson represented Mr. Christensen and the plaintiffs in the case. What did you do? That's the limit of the discussion. And to go beyond that and to say that it's an automatic trigger for expert fees is just contrary to the case law that I've cited.
And Mr. Frederick, maybe I'm going back and I actually pulled up the trial judge's order, and this is where I want to comment on. The judge basically said, the trial court statement, quote, "You asked a lawyer to show up and talk about his lawyering, and that's expert witness, and that's expert testimony." I want you to comment on that.
In fact, I was just about to comment on that. It's the same thing as a doctor being asked to call and testify as to why did you take out this organ? Why did you cut this muscle? What were you doing? I was asking questions as to why did you take this step in doing this action? Why did you file this motion to dismiss? And I don't have the particular that question, but the points that we were discussed are, did you have no charges on your billing slips? Are there any duplicative entries? If there are, did you charge my client for that? Paralegal work. All that's lawyering, and that's all facts, things that he had to establish and that we had to talk about to establish as a competent substantial evidence.
And I'm curious, Mr. Fred, is it the reason, and I know there's been some, for lack of a better word, a little bit bad blood between him and the client. If we're dealing with he rendered services in this matter. So let me just kind of pose this hypothetical. If a request for admissions was provided to him that you're claiming X amount for fees for services rendered, and if he responded, agreed, it ends the inquiry. It's a factual determination. Here's the amount. This is what he's entitled to, period, correct? But in this case, we've gone a little bit beyond that because he did not set forth an affidavit. He insisted on getting a deposition. And I guess I'm trying to reconcile with the fact that, okay, is he a factual witness? And the questions that you've asked him, you're very careful in asking those pointed questions as to what specifically he has done in this case. Did you ultimately ask him the question, the conclusion that is the work that he has done, everything that he's done, was that reasonably necessary for the performance of his obligation?
Yes. Why did you do the work? Was it reasonably necessary for you to do the work at that time? And I think it's a valid question to ask attorneys. When you do something, why did you do it? Was it necessary at the time for you to do that? And the lawyering versus it harkens back to when he's testifying at this deposition. If we award him the expert fees, he's basically being rewarded for not signing that affidavit. And the affidavit, and it was signed by the other, it was a 2-page affidavit, as simple as that. Frankly, it's straightforward. And at the time there was, I guess, bad blood between my client and Mr. Essenson. It's clear from the record. I mean, certainly they were not, friends at the time, but to be obstinate and refuse to execute an affidavit, require us to take the steps necessary to get that information, which we do with hostile witnesses. If the witness doesn't want to talk, we have to send them a subpoena and depose them. This is what we had to do. We had to serve the subpoena. We had to depose Mr. Essenson. He was the head of the firm. He had all the information that I needed. I didn't have to depose a records custodian and then depose Mr. Essenson or any of that. And I harken back to the point that I made earlier, that this case was heavily litigated and I needed to cross the T's and dot all the I's. And that's what happened. And to just simply refuse to sign the affidavit, which he doesn't have an obligation to do so, I admit that. But my client is entitled to get facts and get competent and substantial evidence for the record to establish what he's entitled to be awarded as a prevailing party in the case. So I harken back to the point of why was his deposition testimony sought after and required. That's to establish the competent and substantial evidence for attorney's fees to be awarded. And he was not called to testify to provide opinion testimony. There was a separate attorney that provided that expert opinion testimony. That is undisputed. And the threshold issue is necessary to be determined. And this is analogous to being a doctor. Treating physicians are generally not treated as expert witnesses for an expert witness fee. The representing attorney, and there's a scant amount of case law on this point, and I think we can speculate as to why. But the point is the doctor analogous cases is on point to what we have here today. It's not automatic. Just because you give deposition testimony and you could be considered an expert in the field, that doesn't trigger the expert witness fees. And that's the point I think that's missed in the answer brief, and so far that they just think because he's a lawyer and he talked about lawyer stuff, you should get fees for it. That's not what the case law provides. And that's clear based on what this court has ruled on before and previously. And with that, I would also just make the quick point that Rule 1.390 mentions expert witness or skilled witness. The same arguments apply to both if that's brought up. And in addition, we also request that the final judgment be reversed and award my client attorney's fees for opposition to this motion for protective order based on Rule 1.380. And with that, if there are no other questions, I reserve my time for rebuttal.
Okay. Thank you, sir. You'll have 5 minutes when we come back. Mr. Kelly, it's your turn.
Good afternoon. May it please the court. Matthew Kelly on behalf of the appellee James Essenson. I just want to begin, with the issue of an affidavit. Although I do think it is somewhat extraneous to the record as to why Mr. Essenson may or may not have executed an affidavit. As Mr. Frederick said, there was no requirement, to do that. Mr. Essenson didn't feel it was appropriate. He didn't request to have his deposition.
Mr. Kelly, I don't think the affidavit's that important. I guess what's really important is what his testimony was in the deposition. And I don't see any testimony that looks like expert testimony to me. It looks like all fact testimony to me. Why don't you address that?
Yes, Your Honor, thank you. So I'll go to the deposition testimony, and one of the questions that was asked of Mr. Essenson by Mr. Fredericks is question, the work you performed is outlined in Exhibit 3, so these are the billing statements. Answer yes, question, and in Exhibit 4, was the work that you performed reasonably necessary for this case? Answer, the work was reasonable and necessary for representation of Mr. Christian.
Mr. Kelly, I figured that's where you'd go with this, but I can't imagine that that's expert testimony, because any lawyer who's asked if what they did and billed their client for was reasonable and necessary, I can't imagine a single lawyer on the planet saying, no, I just did it for the heck of it.
No,
it's not going to happen.
I would imagine not, Your Honor, but it is still opinion testimony. It is not a factual issue as to whether a piece of work was necessary. And
it's irrelevant information. It's irrelevant information.
But it is information that was sought by Mr. Fredericks nonetheless. And I'll go through this in a second. He did acknowledge this 4 times in the trial court. And again, this is the record that was before the trial judge.
But Mr. Kelly, if I may, because we're all looking at the same thing, and I thought Mr. Fredericks' point was a good one when he said his question was about the necessary work versus the reasonableness of the hours. And so if you look at the deposition, your client, had every right not to sign the affidavit. That's well and good. But then chose to give the deposition. If you look at the deposition, it's all about the services that he provided. What did you do? What did you do? And how do you, and I guess my question is, how do you reconcile that with a treating physician whose testimony, when you take a deposition as a factual witness, as opposed to being an expert witness? I want you to address that for me, Mr. Kelly.
Yes, Your Honor, I will. So, there are factual issues that are elicited by Mr. Fredericks in the deposition, but the question about whether it's necessary, and this kind of goes into the Field Club case a little bit, because a treating physician can be an expert witness as well under 1.390. The question is, what are they testifying about? So in the Field Club case, what the court said was that even though it was reversed on, for other reasons, it noted that a treating physician could properly be considered an expert witness because even though as he was Mr. Lario's treating doctor, he also gave his expert opinions on her injuries and their significance. Well, this is what Mr. Essenson did. It wasn't just about the work that was done. It was about the work and that work's significance. And the necessity of these billing entries, from what I understand about the underlying case, was it was very contested, that Mr. Christensen was a very particular client, and the Turtle Rock was disputing some of these fees as being unnecessary. So whether or not they are necessary is an opinion. It's not something that anybody can answer. Only a lawyer can answer that, and only the lawyer that performed the services can answer that. And what makes it an opinion, I believe, is that it's subject to dispute. So, going to some of the transcripts from the hearing.
Wait. When you said it's subject to dispute, I guess I'm troubled with the fact that it goes back to, if you look at the deposition that was given, and if you look at the specific questions, and if you look at the specific responses, and it's stuff about the work that I have done. This is my services. And then to add that he had another expert coming in and say, yeah, these are reasonable and necessary pursuant to the law. But in here, it goes back to, I guess, to follow what Judge Moore said, it's work, it's necessary work that I needed to do. He's not going to say, oh no, I just billed this. And no, it wasn't, maybe it's really not necessary. We're talking about, we need to have an expert witness to talk to provide information to the judge as to the totality, whether that is these hours were in fact reasonable, whether these hours were in fact needed to be done. Here, we're dealing with what work was done. What did he do? And for me, I see that as a big distinction as to the testimony that he provided.
Yes, I understand, what you're saying, Your Honor. Still, I do believe that whether or not, and this is what the trial judge found, this is what underlied his ruling, is that whether a particular piece of work is necessary is an opinion. So that is opinion testimony, and it's going to be disputed, and it was disputed by the other side.
Mr. Kelly, can I just get a little clear on the timeline here? Mr. Essenson wanted expert fees before the deposition even took place, right? And he objected to the subpoena. He moved for a protective order. So he wanted his expert fees before he even sat for the deposition. So is it really relevant? I mean, do the questions that were actually asked? I mean, maybe that was the reason that the trial court relied on, but he was requesting the fees before he even sat for the deposition. So
yes, that is correct, Your Honor. So he was subpoenaed to appear at the deposition and at the trial. He did file a motion for protective order on two bases. One, that he would be entitled to compensation under Rule 1.390, and the second issue was about the trial. That ultimately was resolved because he didn't have to. The subpoena was withdrawn. He sat for the deposition, and then the hearing occurred after that. So that is the timeline in which this took place. But one other thing.
So what was the basis? If we're relying on what was asked and answered at the deposition, what was the good faith basis for objecting and requesting a protective order before the deposition even occurred?
Based on his understanding of what was going to be asked of him at the deposition, and the fact that the subpoena was directed to him personally as an attorney, instead of, let's say, a records custodian, if it was truly about the billing records, authenticating them, and the factual, what work was done in those billing records, and this is something that was noted by the trial court, it was directed to Mr. Essenson personally. So he believed that he would be an expert witness under 1.390 and move on that basis. And that's why it was filed before. And, back to this factual issue of, whether it's just about the work that was performed or whether it's just about the bills being authenticated, that could be done by a records custodian. And that's often how medical bills are going back to that analogy, that's how you get them and that's how you can authenticate them, as well as some of the work that was done. But
isn't for physicians, for medical bills, you can't just have you still need to have testimony from the treating physician saying, yeah, I those bills are reasonable for treating. I'm not talking about an expert for treating. So just authentication alone that, oh yeah, these are the bills, that's not sufficient in order for that to happen. So I want to make that clarification. Mr. Kelly, are you stating otherwise?
No, I'm not saying otherwise. The argument being that essentially, if it was just about the factual issues, which is what the appellant's argument is, the factual issues of what work was done and what the billing amount was, and I believe this is part of what Mr. Fredericks just argued a moment ago.
Never actually seen a records custodian testify to that. It's always been a lawyer. And all my years of doing this, it's always been a lawyer, always.
Yes, and it typically would be, and I think this circumstance is a little bit different because most of the times when this would come up, that lawyer is probably still representing that client. This is a little different. The circumstances, the backdrop of this at the time, there was a bar complaint filed with Mr. Christensen. They were in separate litigation together.
No question there's bad blood here. That's abundantly clear. You guys are here fighting over a $6,000 attorney bill. That tells us all we need to know.
It's actually, Your Honor, it's a $712.50 expert fee award.
That part of it is, but you got this $6,532.50 for the fees and getting the protective order, right? So
that's
you're
correct.
fighting about that too, right?
No, that was stipulated too between the parties.
You're only fighting over $712.50? That's
correct, Your Honor.
That's bad blood right there.
So, and our view of that is that Mr. Essenson was subpoenaed to sit for this deposition. And he did, and he was asked his opinion about whether the work he performed was reasonably necessary for representation of Mr. Christensen. He gave that opinion. That deposition transcript in its entirety was entered into evidence in that proceeding. And based partially on that, Mr. Christensen did receive an award, I believe, in excess of $225,000. And this appeal and the two hearings that we had before the trial court are simply about that $712.50 expert witness fee. And, when we look at Rule 1.390, I think that clearly Mr. Essenson fits into that. He is an expert, and I think Mr. Frederick said it's not a dispute that he meets those qualifications. So it's really about, was he possessed of special knowledge or skill about the subject upon which he was called to testify? And the trial court found that he did, because of that opinion about whether it was reasonably necessary. That is part of the trial court's analysis in the underlying fee dispute. The prevailing party fee dispute is whether it was. He gave his opinion on that. It's not a factual matter because it's not just about whether he represented him or how many hours were expended. It's whether it was reasonably necessary for the representation of Mr. Christensen. And, you know, it can't be just anybody that answers that question. It can't even be the records custodian. It has to be Mr. Essenson, and it's because of the special knowledge and skill that he possesses about that subject matter. And that's what makes him meet the definition of an expert under 1.390 and makes him entitled to that $712 fee. So I want to talk about I talked about the Field Club case a little bit, and that being that essentially a treating physician can also be an expert if they talk about or give an opinion about not only what was done, but on its significance. And I relate that to Mr. Essenson's testimony about whether the work was reasonably necessary. Another case that I'll talk about that was cited in the briefs, just briefly, is Petrie v. Petrie. And one of the things the court said in that case was that to qualify as an expert witness, the witness must have such skill, knowledge, or experience so as to make it appear that his or her opinion will aid the trier of fact in a search for the truth. Now, in the—
Mr. Kelly, I just thought of something and it helped me out. If we take your position that Essenson's testimony, he is an expert, he should be considered to be an expert witness, that means that could his testimony alone constitute substantial competent evidence to support the fee award? And if the answer is yes, why did you have another expert witness come in and testify to support that?
Well, I think that it would be expert testimony, but I don't think that just because you have to have a corroborating expert means that the question that Mr. Essenson was asked was not an opinion of an expert. I think in this case, you'd have two. Now, and a lot of
but then an objection to bolstering would be sustained, and that second witness wouldn't be able to testify because simply bolstering the testimony of the first witness.
Well, I guess what I'm saying is, so that if he has a designated expert witness in the case, I don't think that that means that question that was asked of Mr. Essenson does not constitute an expert opinion. And it is on somewhat of a different matter because the expert, the fee expert in the underlying case is going to be testifying about the reasonableness of the fees and some of these other matters. The question that posed to Mr. Essenson was about the reasonable necessity of the work. So it's really this all comes down to whether or not that's an opinion, and it's an opinion, one that only an attorney can give, or the attorney who performed the services. And given that, that's what makes it fit into 1.390. So I don't think that just because there has to be a separate witness, expert witness, I don't believe that that would then render Mr. Essenson automatically a fact witness. And if you look at some of these cases where we have treating physicians, in those cases, presumably as well, they had a separate expert too. It's about the nature of what's being asked. And in this case, similar to some of these treating physician cases, it sort of crosses the line from just fact issues into an opinion, which is, was this work necessary? Why is this work done? That's an opinion question.
And whether the opinion is ultimately admissible or not is beside the point.
Well, I will say that in this case, it was that the deposition transcript in its entirety was admitted into evidence. But I would say, whether this is a first party compensation case in the sense that 1.390 is between the deposing party and the deponent. This is not a taxable cost case, which some of the cases cited by appellant are taxable cost issues. And when you have a taxable cost issue, you have the additional requirement that it be that the taxable costs have been reasonable and necessary. So I think maybe that would come into that analysis if, let's say, they were trying to recover this against the third party. well, was it reasonable and necessary to ask him that question? I think is where that analysis would come in.
Mr. Kelly, I wanted to give you, when you have a few minutes remaining, is to give you the same opportunity that I've asked Mr. Freitas. Mr. Essenson relies on the trial court statement, quote, "You asked a lawyer to show up and talk about his lawyering, and that's expert testimony." Isn't that kind of not really the state of the law?
Well, I think that he was sort of, the trial judge did go into a little bit more detail than that. I think he was sort of surmising at the end. I'll point here to another part. This is from the March 3rd, 2020. So this is the rehearing. And one of the things the court says in making his rulings that I'm probably being rhetorical, but why did you have him do the work that he did sounds an awful lot to me like an opinion by an attorney as to why a particular piece of work was necessary versus unnecessary. And that's what the trial court relied on in part in deciding that Mr. Essenson did give an opinion and therefore was an expert under 1.390. And I believe that that is the correct analysis because once again, only an attorney and that attorney in particular can give that opinion. And it is opinion because it's not a fact in the sense of, some of the other examples that Mr. Fredericks gave is whether or not Mr. Essenson in fact represented him, what work was done. Once you get into, why it was done or the importance of it, I think that becomes an opinion. And that's what makes him an expert witness under the rule. And that's sort of analogous to the treating physician analysis, which is now we're getting into the significance of the medical services that were provided rather than just a factual matter of whether or not they were. Does that answer your question?
It does, Mr. Kelly. And it prompted me another question, but I don't want to keep on peppering you, so I'll remain quiet. No
I'd be happy to answer. Okay. So one other case that I did want to point out is the Rodriguez versus Campbell case. That's a prevailing party attorney fee case. It was reversed for failing to include findings regarding number of hours reasonably expended or reasonably hourly rate. So it's not quite applicable in this context, but the court makes a couple of comments that I think are instructive. In rendering its ruling, the court states, quote, "Finally, we agree with the Rodriguez's that an award of attorney's fees must be supported by expert evidence, including the testimony of the attorney who performed the services." The court then goes on to say that when the record contains some competent substantial evidence supporting the fee or cost order, yet fails to include some essential evidentiary support, such as testimony from the attorney performing the services or testimony from additional expert witnesses, the appellate court will reverse and remand. And the reason I even bring that case up, and I know that that's not, it's dicta in some sense, but it is that what was being asked before about, well, he has a separate expert witness, so how can he have two? The opinion of that attorney is an expert opinion. Only an attorney can answer it. And this is part of what the trial judge said. Only an attorney can answer that question.
Yes, and if I may, Mr. Kell, the main reason I asked you that question, because there's a case from our court, I don't know if it's referenced in the brief, the Yakubik case. And in that case, this is the Yakubik versus Board of County Commission. And basically what our court said that the testimony, it deals with the testimony of an expert witness concerning reasonable attorney's fees is necessary to support the establishment of the fees. And in that case, what we wrote, that the only evidence offered to support the award of the attorney's fees was the attorney who performed the services. And then we said the trial court erred in establishing the amount of attorney's fees, in this case, based solely on the testimony of the attorney seeking the fees without testimony from expert witness as to the reasonable amount of the fees. And so that's a state of the law here. And I think it delves into, and I think it makes sense. Oh, all right.
We're out of time. Sorry, Mr. Kelly. You're not going to, if that was a question, you're not going to be able to answer it.
Okay, I apologize. All right.
All right. So let me see. So Mr. Fredericks, you've got 5 minutes. You got to unmute your mic, sir. I'm sure that was brilliant, but we didn't hear it.
I'll have to see if I can get back that brilliance back. I just want to touch on a couple of points. One of them being what Judge Youakim brought up as far as when this motion was filed, which is before the deposition, which also sought these expert witness fees. And opposing counsel mentioned that he filed that because he thought he was going to be testifying as an expert. Problem with that is the transcript, which is part of the record, says that he didn't know what he was testifying about. And in fact, he states in here, I already told you, I don't know why I'm here. He didn't know why he was there. He didn't know if he was going to be testifying as an expert. He didn't know what he was talking about. He went there, and I'm not going to get into conjecture or speculation, but he did not know why he was there, and he says it, and that's part of the transcript of this deposition. Another point to be made is that talk about lawyering, that frankly makes my point. A lawyer can not, he can talk about lawyering what he did, and the only person that can do that is the lawyer that did it. Why did I do this step? Why did I do X, Y, Z? And that's the whole point of the deposition, is what did you do? And to give an opinion about your own stuff, I think that's the whole idea of having the separate expert opinion, which was well pointed out as far as the Ukabek case, and that you need that separate expert to testify as to the reasonableness of those fees. And the point of why he was called to be deposed is I think, a major point to be considered. He wasn't just testifying just because. There were specific things that needed to be established, facts, competent, substantial evidence that only he could provide. Separately, and based on the case law, and based on how litigious this case was going to be, and how litigious this case was, every step needed to be done properly and correctly, which was done, which is when we had a separate expert come in and testify as to that reasonableness. So with that, unless there are any additional questions, I would again reiterate that the judgment should be reversed. Oh, I'm sorry, I do have one more point. There was discussion about how much we're at issue here. The final judgment is being appealed. That's the 712 for the expert fees, as well as the attorney's fees awarded for filing the motion. That was not stipulated to. There was an amount stipulated to get to the final judgment, but the issue of whether or not they were to be awarded that is at issue and appealed as well. So it's not just $712. This is the overall, the motion filed. Are you entitled to the expert fees? And are you entitled to your costs in incurring and getting this order? So it's not simply just $712 at this point. So I want to make that clear for your honors. But with that, unless there are any questions, I'd rest at this point.
Thank you very much, gentlemen. Thank you both. This concludes our docket today. We will we're adjourned to deliberate all the cases.